Hello and a very warm welcome. Thanks for tuning in to News 9 Live. This is a special broadcast that you're catching from our studios here in the National Capital Region. And our focus is, of course, going to be that big verdict that's come out of the Supreme Court, ladies and gentlemen. The Supreme Court, after hearing this batch of petitions that challenged the abrogation of Article 370 back in 2019, when it was repealed from Jammu and Kashmir, the special status, the special autonomy, the state that it had and, it enjoyed was taken away. And now the Supreme Court has upheld the constitutional validity and the process of the government, how it was abrogated. And not just that, the bifurcation and the Reorganization Act of Jammu and Kashmir that bifurcated Jammu and Kashmir into two union territories of Jammu and Ladakh, well, that has also been upheld by the Supreme Court. Before we begin, and we've got various reactions, colorful visuals coming across from Srinagar, from Jammu. We've got our reporters placed in Lal Chowk in Srinagar. We've got a reporter placed right outside the Supreme Court, the Apex Court's premises, talking to the common people, how they're, reeling in with this new verdict, that this judgment that has come out of the Supreme Court. First and foremost, let's take a look at the top points that were put across by the Chief Justice of India. It was a unanimous decision, albeit there were three different judgments that were put out, but there was proper concurrence. The constitutional validity has in fact been upheld. Take a look at this, ladies and gentlemen. The Supreme Court has upheld the abrogation of Article 370. Now, of course, the community stands divided, be it political leaders, be it the Kashmiri pundits, be it the activists, be it the Muslims in Kashmir. It does look at this particular moment in time that the community is divided. But in the meantime, the Chief Justice of India said that Jammu and Kashmir did not retain the element of sovereignty after joining with the Union of India. Again, major operative parts there by the Chief Justice of India. He says Jammu and Kashmir, it did not have any sovereignty after it joined the Union of India. The Chief Justice of India has also said that Article 370 is a temporary provision. So a lot of debate that was going on already about whether it was permanent, whether it was temporary. If the Constituent Assembly of the Jammu and Kashmir ceased to exist, did Article 370 automatically subsume a permanent role? That was a big question, and the bench, the 5-judge bench, which heard this batch of petitions for about 16 long days, had to adjudicate on this particular aspect as well. Article 370, it's not permanent, it's temporary. That's been upheld by the Chief Justice of India. Another important point, ladies and gentlemen, all provisions of the Constitution can be applied to Jammu and Kashmir. Of course, a lot of ifs and buts over there. How soon will everybody from India be able to buy land over there? When a woman from the state of Jammu and Kashmir ends up marrying somebody outside the state, the retention of citizenship, that's also part of the abrogation of Article 370. How will that be implemented? All of those questions are there, but importantly, the CJI has upheld the abrogation of Article 370. Let's take a look at the next point. Now, the Supreme Court, again, very important aspect here, because in the course of the petitions and the hearings, the 16-day long hearing, the entire trial, it was categorically said again and again by the government, this was government's argument, that full restoration of statehood is something that the government is in fact working on. First, it's going to be the municipal polls, it's going to be the panchayat polls. What is stopping them from carrying out a full-blown assembly elections? Well, this point right here, take a look. SC has directed the Election Commission to in fact carry out or hold assembly elections in 2024 in the month of September. A particular date on that, well, let's not jump the gun, let's not put that date, but you can expect assembly elections in Jammu and Kashmir, full restoration of statehood, that's likely on the cards. Now, CJI has said that statehood of Jammu and Kashmir shall be restored as soon as possible. So again, like I said, not a date that's been given, but then again, it can be expected, it's likely to be on the cards. If you did in fact hear the hearing, the judgment that was put out by Chief Justice of India, D.Y. Chandrachud, he said that September 2024, carry out assembly elections. Meanwhile, let's take a look at the other point. It says SC cannot sit in appeal on presidential order. Another important aspect, because 356, 370, 360, 368, several of those articles, all those IS aspirants out there, people who are from the world of, law, they understand the legalities. Well, we'll have to, get in touch with them. And we've got some experts who are joining us on the panel as well. We'll take those questions with them. Another important point, SC has struck down Constitutional Order 272 as ultra-virus. This is another important point that has been put across. All in all, the bottom line continues to be that the Chief Justice of India, this 5-judge bench, the Supreme Court, has upheld legally the constitutional validity of abrogation of Article 370. Take a look at some of the operative portions, the operative parts from the Supreme Court today. Courtroom number 1, all the top judges of the country, they got together, they presided over this particular hearing. There were 3 different judgments, albeit it was a unanimous decision. They were all in concurrence with each other. Take a look at some of these operative portions, and then we'll show you some colorful visuals that are coming across from Srinagar. We'll talk to people who are right outside the Supreme Court, common people, people who are politicians, members of parliament, and of course the major stakeholders over here. Voices coming out of Kashmir as well. But before all of that, let's cut across to what Chief Justice of India, D.Y. Chandrachud, had to say, operative portions only.
The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was mala fide. Having concluded that the power under Article 370, Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power. The validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into 2 union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a union territory is upheld because Article 3A, read with explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
Well, we'll continue to play out more operative portions from what D.Y. Chandrachud, the Chief Justice of India, what he had to say as he and the other members of this constitution bench upheld the constitutional validity of the abrogation of Article 370. Meanwhile, several of our reporters that are stationed in Lal Chowk at the Supreme Court premises, I'm being told we're going to cut across to them very shortly. Meanwhile, Deepshikha Bharti, advocate for the Supreme Court, is with us on the broadcast. A very warm welcome to the broadcast to you. Right at the forefront, your opinion, your initial thoughts. I mean, this is a major judgment that has now come out of the Supreme Court. 16 days long hearing, the actual societal pain points on the ground vis-a-vis the political construct. So many things happening at the backside of this. Since 2019, it's been 4 long years. What is it that you thought after you heard what the CJI had to say? Was it something that you were expecting? Initial thoughts, ma'am?
Yes, I'm first of all thankful to you. There is 5 judges and 3 judges. This is a main thing. The 3 judges are concurrence. They had given that order, and the Chief Justice has already given value to the demand of public, and Justice Kaul has also supported that. Justice Sanjeev Khanna has also supported that because of long back, since long, there is a violence. Human rights, they have Justice Kaul has already insisted that there should be commission for the violence and for the investigation of that, the sufferer and the victims for that time. That is why there is a public demand for this 370 should be repealed. And we received earlier 5 judges. Just I wanted to tell you, 5th of September, that pronouncement was of 5th of September reserved. That judgment was reserved and which is pronounced today. In this, there is a 2-3 questions for more important: validity of constitution, precedents or power, governance power. Under 356 SR Bombay, they have not covered all the issues. In Sampath, there is a first, Justice Chanchur has said that there is a 370 is a temporary because that in Premnath call and Sampath Prakash case. In Sampath Prakash case, there is a I can say this is a in case of, they said this is a permanent, but that issue was not, there is not conflict in both the cases, but that issues was not raised in Premnath call case. Then Rameshwar Prasad in 356 under Article 356, they had, they told that this is not, this is also 356 is not totally valid for regarding this. This challenges actually these for the present situation and circumstances. It is necessary and it is demand of the public because of sufferer, because of the challenges raised by the public, and they are victims because they are not getting integrity. Justice Kaul has said that it should not be disintegrated, it should be integrated. So
Right,
India
right.
should be, yes. So just justice and all the 3 judges has given that concurrence, and there is more for the abrogation. This is this first part is already temporary and permanent. So
No, I do concede that there are going to be a lot of ifs and buts. I mean, the constitutional validity
Yes.
has been upheld, but what next? What on from now? Well, we'll have to wait and find out. Deep Shekhar Bharti, do stay on with us. Let's quickly cut across to my colleague who's currently stationed in Lal Chowk. Let's cut right across. Irfan Qureshi, if you can hear us here from the studio, what are scenes like over there? We were getting earlier visuals from Srinagar and Jammu. सब एक दूसरे को मिठाई खिला रहे थे, नारेबाजी हो रही थी जय हिंद की. The tricolor was being, it was the only color that you could see filling up the sky as well. क्या कुछ बता सकते हैं अभी आप वहाँ से?
See, you are right. There are different scenes from Jammu and Kashmir. In fact, in Kashmir today, morning starts from the complaints being made by Mehbooba Mufti and Umar Abdullah that they have been kept to house arrest. However, that was more quickly rebutted by the Lieutenant Governor Manoj Sena and Srinagar police, saying that they are free. But so far, people here are definitely witnessing a normal life today. However, there were some security arrangements as precautionary measures. But on the other hand, there are 2 different factions in mainstream politics of Jammu and Kashmir. Some people say that they are happy with the decision, as their only demand was to see the restoration of statehood, and the elections should be held as soon as possible in J&K. But as you know, the Gupkar Alliance political parties were demanding a complete revocation of what happened on 5th August 2019. They are definitely disappointed, and Umar Abdullah has tweeted and made it clear they are disappointed, disheartened, but they will keep fighting. On the other hand, Mehbooba Mufti also talked about the verdict given by the Supreme Court and said that they will continue to fight and they will not lose hope. So it is clearly now that in Jammu and Kashmir there will be a huge political activities from especially the Gupkar Alliance in coming days, while People's Conference or Apni party, like political parties, somehow are moderate in their statements, saying that the elections and the restoration of statehood should be done as soon as possible. People should be given their democratic right to choose their government, and development must be the priority of the central government in Jammu and Kashmir, which has been, not given to the people of Jammu and Kashmir since long now. Especially about the Reconciliation Commission, Kashmiri Pandit are very excited, saying that this was much needed, and the Supreme Court has finally talked about them and make it sure that justice will be given and it should prevail. On security front, there were apprehensions that there could be some law and order problem in some sensitive places of Kashmir Valley. Security deployment was kept on standby. However, there was no restrictions for the normal movement of people in any part of Kashmir, except some frisking was definitely seen in Gupkar Road, where Mehbooba Mufti, Omar Abdullah and Farooq Abdullah is stationed. That was done somehow as a precautionary
if you can hear me, also touch upon the fact that now the Supreme Court has said that there are going to be assembly elections soon, like as soon as possible, could be as early as September in 2024. How big of a statement is this coming from the CGI itself, clearly telling the Election Commission that, hey, you know what, now that you've carried out these panchayat elections, these municipal polls in various areas, how about we go around and get the assembly elections done as well? How big is this for Jammu and Kashmir?
See, definitely this is a very big and a much needed relief for the people of Jammu and Kashmir, since the elections have not been held from last so many years. In fact, I just talked with a few of the politicians here who are talking about the Supreme Court mentioned about the assembly elections, but raising some questions regarding whether the statehood should be restored before the elections are held or after the elections are being conducted in Jammu and Kashmir. That is what needed to be watched, and that will be a big difference in the political scenario of Jammu and Kashmir. If elections are held after the restoration of statehood, then definitely the political parties like Gupkar LNS will be eyeing that, and maybe some political analysts also pointing out that they will be definitely trying to attempt revocation of some of the orders that have been issued since 2019. It will be a big political fight from Gupkar Alliance, as they have mentioned and pointed out that they have not lost hope and they will keep fighting for their rights. But for people, it is much needed relief, and as it is over, Supreme Court has definitely made it clear that Article 370 was temporary and people should move on. That's what people also believe, they should move on.
Absolutely. I mean, Omar Abdullah also was very quick to take, his stand on X, formerly known as Twitter, saying that, it's a long haul and we're ready for it. It took BJP so many years to reach to this point. The fight is going to continue. Meanwhile, Piyush Pandey, my colleague, joins us from the Supreme Court premises. पीयूष, कुछ तस्वीरें दर्शकों को यहाँ पर दिखाइए, क्या कुछ बता सकते हैं, किन तरह की एडवोकेट से आपकी बात हुई, कुछ खास दलीलों के बारे में आपको पता चला?
जी बिल्कुल, देखिए बहुत सारे वकील जो इस मामले में याचिकाकर्ताओं के पक्ष की ओर से पेश हुए थे सुप्रीम कोर्ट में, उनसे हमारी बातचीत हुई। खास तौर पर 23 याचिकाएं थीं और इन 23 याचिकाओं में 11 वो याचिकाएं थीं जो केंद्र सरकार की ओर से जो 370 हटाने का फैसला था उसके पक्ष में थीं। तो उस पर सुप्रीम कोर्ट के फैसले पर उन्होंने काफ़ी खुशी जताई और सीधे तौर पर ये कहा कि सुप्रीम कोर्ट ने इस मामले में जो संसदीय प्रक्रिया थी उसको ऊपर रखते हुए सीधे तौर पर जो खिलाफ याचिकाएं थी उसमें जो चुनौती दी गई थी कि किसी भी तरह से संसद ऐसा निर्णय नहीं ले सकती, यानी कि विधानसभा को भंग करने का राष्ट्रपति शासन जब लगाया गया उसके बाद संसद की ओर से जो सिफारिश की गई कि 370 आर्टिकल 370 को हटा दिया जाए, तो ये सिफारिश नहीं की जा सकती थी। इस पर सुप्रीम कोर्ट ने अपना स्पष्ट फैसला रखा है और केंद्र सरकार की ओर से 2019 में जो निर्णय लिया गया था उसको अपहेल्ड किया है। इसके अलावा जो राज्य का दर्जा दिए जाने की बात थी उस पर भी सुप्रीम कोर्ट ने बड़ा स्पष्ट रुख अपनाया और कहा है कि राज्य का दर्जा जम्मू कश्मीर को दिया जाए, जबकि जो लद्दाख है उस पर केंद्र सरकार की ओर से कहा गया था कि वो लगातार उसे केंद्र शासित प्रदेश के दर्जे पर ही रखा जाएगा और उसे भी सुप्रीम कोर्ट ने माना है अपने फैसले में। इसके अलावा चुनाव संबंधी जो तकनीकी बातें थीं उन पर भी सुप्रीम कोर्ट ने इस मामले में सुनवाई की थी और आज सुप्रीम कोर्ट ने इस मामले में इलेक्शन कमीशन ऑफ इंडिया को निर्देश दिया है कि वो अगले साल यानी 2024 में सितंबर तक घाटी में चुनाव कराए और लोकतंत्र को बहाल करे। यानी कि सुप्रीम कोर्ट का जो फैसला है वो अगर आप देखें तो बड़े पैमाने पर व्यापक स्तरों के पहलुओं पर गौर किया गया है उसमें, और हर एक पहलू पर पूरी तरीके से रुख को स्पष्ट किया गया है सुप्रीम कोर्ट की ओर से। 3 फैसले दिए गए हैं और 5 जजों ने सर्वसम्मत फैसले दिए हैं। कुछ एक पहलू थे, इसी वजह से 3 जजों ने अलग अलग फैसले दिए हैं। जी।
Alright, Piyush Pandey live from the Supreme Court premises. Meanwhile, ladies and gentlemen, let's quickly cut across to some live reactions that are also coming in. Some former chief ministers of Jammu and Kashmir, be it Mehbooba Mufti, Ghulam Nabi Azad, Omar Abdullah, and several other major stakeholders as well. Listen into these voices and we'll come back for more.
मेरे प्यारे हमवतनों, हिम्मत मत हारो, उम्मीद मत छोड़ो। जम्मू कश्मीर ने बहुत सारे उतार चढ़ाव देखे हैं। सुप्रीम कोर्ट का आज का फैसला ये एक पड़ाव है, मुश्किल ही सही पर पड़ाव है। ये मंजिल नहीं है हमारी, इसको मंजिल समझने की गलती मत करो। हमारे मुखालफिन चाहते हैं कि हम उम्मीद छोड़ के दिल बर्दाश्ता होके शिकस्त को तस्लीम करें, पर ऐसा नहीं होना है। आप जानते हैं कि सुप्रीम कोर्ट ने यह कहा कि 370 आर्जी है, इसलिए इसको हटाया गया। ये हमारी हार नहीं है, बल्कि आइडिया ऑफ इंडिया की हार है, हिंदुस्तान के तस्वुर की हार है। जिस तस्वुर के साथ, जिस आइडिया ऑफ इंडिया के साथ, जिस गांधी के हिंदुस्तान के साथ, जिस गंगा जमनी तहजीब के साथ जम्मू कश्मीर के मुसलमानों ने पाकिस्तान को दरकिनार करके यहाँ के सिखों के साथ, यहाँ के बुद्धिस्ट के साथ, यहाँ के क्रिश्चियंस के साथ, यहाँ के हिंदू भाइयों के साथ गांधी के मुल्क के साथ हाथ मिलाया, आज ये उस आइडिया ऑफ इंडिया की हार है। आज जो हरकत मरकजी सरकार ने पार्लियामेंट के अंदर नाजायज, गैर कानूनी, गैर आईनी की, उसको जो जायज करार दिया गया, वो जम्मू कश्मीर के लिए ही नहीं बल्कि आइडिया ऑफ इंडिया, हिंदुस्तान के तस्वुर के लिए एक सजाए मौत की खबर से कम नहीं है। आप जानते हैं 1947 में एक सरकार थी, पार्लियामेंट था, उसके बाद कॉन्स्टिट्यूशन बना, उन्हें जम्मू कश्मीर के साथ वादे किए और जम्मू कश्मीर को एक खुसूसी पोजीशन दी। उसके बाद 77 साल के बाद एक दूसरी जमात आई जिन्होंने पिछले 77 साल से एक ही रट लगाई थी कि हम पावर में आएंगे और 370 को खत्म करेंगे। उन्होंने कर दिया, मगर ये हमारी हार नहीं है, ये इस मुल्क की हार है। धोखा उन्होंने किया, हमने तो नहीं किया। आज 370 को आर्जी कहते हुए उन्होंने मुल्क को कमजोर कर दिया। उन्होंने जम्मू कश्मीर में उन ताकतों को मजबूत किया जो बार बार कहती थी कि जम्मू कश्मीर का मुल्क के साथ इल्हाक आर्जी है। तो आज 370 को आर्जी कहते हुए आपने जम्मू कश्मीर का जो रिश्ता है उसको आर्जी करार दे के उसको तोड़ दिया। जो हाथ आपसे मिला था उम्मीदों के साथ 1947 में, आज आपने उस हाथ को जख्मी कर दिया। इसलिए हिम्मत मत हारो मेरे भाइयों, मेरी बहनों, मेरे बच्चों, ये वक्त भी नहीं रहेगा। मैं अपने देशवासियों से कहना चाहती हूं, आप में से कई लोग इस वक्त जश्न मनाते होंगे जम्मू कश्मीर के लोगों के आंसू देखते हुए, उनकी तकलीफ देखते हुए, जो जम्मू कश्मीर को आज फिर से जेल में कन्वर्ट किया गया। दुकानदारों को बोला गया, उनको धमकी दी गई कि सुबह 10 बजे दुकानें खोल दो। हमें घरों में नजर बंद किया गया, वर्कर्स को थानों में बंद किया गया। तो इससे डरने की जरूरत नहीं है, इससे घबराने की जरूरत नहीं है। मैं अपने लोगों से कहना चाहती हूं, मैं अपने मुल्क के लोगों से कहना चाहती हूं कि जो 2019 5 अगस्त को हमारे मुल्क के संविधान के साथ हुआ, जिसकी वजह से हमारा अपना छोटा सा संविधान छीना गया, हमारा झंडा जो तिरंगे के साथ छोटा सा झंडा था उसको छीना गया, ये बात यहां रुकने वाली नहीं है। जो शुरुआत जम्मू कश्मीर से हुई है वो पूरे मुल्क में फैलेगी। जो हमारा संविधान है, बड़ा संविधान है, जो तिरंगा है, जिसके नीचे आजादी की लड़ाई लड़ी गई और जीती गई, इसको भी आपसे छीनने में जरा देर नहीं लगाएंगे ये लोग। मगर उस वक्त हम आपकी तरह जश्न नहीं मनाएंगे, बल्कि दुआ करेंगे कि आप भी हिम्मत और हौसले के साथ इनका मुकाबला करो। मैं फिर से अपने जम्मू कश्मीर लद्दाख के लोगों को कहना चाहती हूं, मेरे भाइयों, मेरे बच्चों, मेरी बहनों, हिम्मत नहीं हारनी है, किसी भी सूरत में नहीं। कोई फैसला अटल नहीं होता, चाहे वो सुप्रीम कोर्ट का ही क्यों ना हो। हमारे लिए कोई फैसला अटल नहीं। ये एक सियासी लड़ाई है जो पिछले कई दहाइयों से चल रही है। हमारे लोगों ने बहुत कुर्बानियां दी हैं इज्जत नफ्स हासिल करने के लिए, हम इसको अधूरा नहीं छोड़ेंगे, मगर बशर्ते कि हम इकट्ठे हो जाएं, एकजुट हो जाएं और ये लड़ाई, ये जद्दोजहद इकट्ठे लड़ें। मैं आप सबकी बहुत शुक्रगुजार हूं, आपने मेरी बात सुनी और उम्मीद करती हूं कि आप दिल में नाउमीदी, शिकस्त को जगह नहीं देंगे, बल्कि उम्मीद के साथ, एक नई उम्मीद के साथ, एक नई जद्दोजहद के साथ आगे चलेंगे।
जो यूनानिमस जजमेंट थी, ये सर बहुत निराशा हुई, बहुत अफसोस हुआ। मैं शुरू से ही कह रहा था कि दो अदारे हैं जो इसका फैसला कर सकता है, एक पार्लियामेंट, मरकज़ी सरकार, और दूसरा सुप्रीम कोर्ट। जाहिर है मरकज़ी सरकार करती नहीं, उन्होंने तो आर्टिकल 370 को ख़त्म किया, कानून बनाकर नया। अब ये आखिरी हमारी उम्मीद थी कि सुप्रीम कोर्ट इसमें सुनाई करे और इसका फैसला सुनाए। 3 महीने 4 महीने इस पर बहस हुई पार्लियामेंट के अंदर, और मुख्तलिफ वकला ने अलग अलग पार्टीज़ को और रियासत जम्मू कश्मीर के लोगों को रिप्रेजेंट किया। और उसके बाद जो आज यूनानिमस फैसला आया, उससे मेरे ख्याल में जम्मू कश्मीर के सभी लोग, चाहे वो कश्मीर के हों या जम्मू सूबा के, वो खुश नहीं है। मैं आज भी समझता हूँ कि ये हमारे रीजन के लिए एक हिस्टोरिकल चीज़ थी। हमारे जज्बात जम्मू कश्मीर के लोगों से इससे जुड़े थे, चाहे वो 370 हो या 35A हो, जिस 35A को महाराजा हरि सिंह ने 1925, 1927 और 1928 में बनाया था कि बाहर वाला न नौकरी कर सकता, न बाहर वाला ज़मीन खरीद सकता। और जब हमारा आईन बना तो 35A की शक्ल में उस महाराजे को फैसले को आगे बढ़ाया था। तो आज वो भी ख़त्म हो गया, दोनों चीज़ें ख़त्म। इससे हमारी स्टेट की इकानमी को बहुत नुकसान होगा, ज़मीनें महंगी हो जाएंगी, पूरे हिंदुस्तान के लोग जम्मू और श्रीनगर आएंगे। हमारी महदूद, हमारी यहाँ कोई बड़ी इंडस्ट्रियाँ नहीं है कि जिसमें हज़ारों या लाखों लोग काम करें। हमारी सबसे बड़ी इंडस्ट्री है टूरिज़म, और वो लिमिटेड लोगों के लिए है। हमारी सबसे बड़ी इंडस्ट्री जम्मू कश्मीर की है नौकरी, सरकारी नौकरी, और उसमें भी अब और बहुत कम नौकरियां होती। ज़ाहिर स्टेट बहुत छोटी है, अब उसमें पूरे मुल्क के 130 करोड़ जो आबादी हमारे में, वो अप्लाई कर सकते हैं हर महकमे के लिए। तो हमारे जो नौजवान बच्चे हैं या बच्चियां हैं पढ़ी लिखी, वो और बेकारी हमारी बढ़ेगी, कई गुना और ज़्यादा बढ़े। तो ये तमाम चीज़ें जब रखी गई थी आर्टिकल 370 में, 35A में, 35A में, इन तमाम चीज़ों को नज़र में रखा गया था कि एक बॉर्डर स्टेट है, एक तरफ से चाइना है, दूसरी तरफ से पाकिस्तान है, और कोई यहाँ ज़रिया आमदनी नहीं है, कोई खदानें नहीं है, बड़े कोयले की खदानें या दूसरी खदानें। तो ये चीज़ें आर्टिकल 370, 35A रखना चाहिए। मैं ये तो नहीं कह सकता कोर्ट से भरोसा उठ गया, लेकिन ये था कि एक उम्मीद थी, क्योंकि कई चीज़ों में हम सब ने, हिंदुस्तान के हिंदू मुसलमान ने पिछले कई सालों से कहा था जो कोर्ट करेगा वो आखिरी फैसला होगा। जैसे बाबरी मस्जिद के बारे में कहा था, इसी तरह से और कई चीज़ों में कहा था और उसको स्वीकार किया था। तो अब हमारी उम्मीद थी कि सुप्रीम कोर्ट, क्योंकि वो किसी दल की, किसी पक्ष की, किसी सियासी पार्टी से ताल्लुक़ नहीं रखते हैं, और ख़ास तौर से आज की जो ये बेंच था वो बिल्कुल मैं कह सकता हूँ कि बहुत ही अच्छा बेंच था।
Well, we'll continue to play out more reactions coming across from major stakeholders, but cutting across to the legal expert with us on the panel right now, Deepshikha Bharti, advocate at the Supreme Court, continues to be with us. Ma'am, also do touch upon the fact that, there are some societal pain points that I would like to take upon with the political expert rather, but taking a look at only the legality over here, federal structure versus integration. I mean, we're talking about precedents that might just end up, dictating what's going to happen to all these other places as well. Several of, opposition leaders have taken to various social media platforms saying that this is now not going to stop at Jammu and Kashmir, Mumbai, Chennai, all these other metropolitans, beware, you might just become a union territory as well. Everybody's citing the example of Ladakh, where, there's a governor general and there's no actual representation per se. From what you've seen happen at the, in the Supreme Court today, the abrogation of Article 370 being upheld by the CJI, what kind of a precedent does this now make or become for the future?
Yes. In abrogation that is valid, CGI has already declared today. And for other states, they cannot occupy that our Indian sovereignty, which is belong to the our Indian Constitution preamble, sovereignty, integrity, and this is the objective of the collective understanding. Why CJI has given this order? There is a demand of public, I told you earlier also, and this is a collective understanding because of since 1947 it happened. It is going on. Now violence was controlled since last few years, and I can say CJI has already explained that and given that clue that emergency farmer is under 356 in SR Bombay case, there was that issues were not covered, not even raised at that time. So nowadays, because of demand and public understanding, collective understanding, the farmer, earlier it was not brought, it was not barred that 356 means it should not be revoked, 370 cannot be revoked. And the second thing is this value of the sovereignty, value of the democratic value to maintain that sovereignty, and that social facts, that is the consequences of since last 1947. The CGI has said that it should be rational. Earlier it was, if we had not revoked that, earlier what they are facing and what was the circumstances and consequence, that was irrational. That was not.
Well, of course, pertinent points being raised there by Deepshikha Bharti, advocate for the Supreme Court. Meanwhile, let's listen into some more operative portions from the Supreme Court as the CJI today delivered that judgment on the batch of petitions that challenged the abrogation of Article 370. It has been legally upheld. The CJI has said, no problem with that. It has been legally upheld. Some more operative portions vis-a-vis sovereignty of Jammu and Kashmir. Did it exist? Did it not exist after joining the Union of India? Listen in from the mouth of the CJI himself.
We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, Paragraph 8 of the Instrument of Accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. the declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination, as understood by the definition of sovereignty, exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Kaul was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the Dominion of India did not arise in that case. All provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 371D. The power under Article 371D can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mind cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the precedent securing the concurrence of the Union of India on behalf of the state government is not mala fide. The previous constitutional orders, which modified Article 370 through Article 367, were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3, by taking recourse to Article 367. The exercise of power by the President under Article 371D to issue CO 272 is not mala fide. The President, in exercise of power under Article 370, Clause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second proviso to Article 370, 1D, while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President, in exercise of power under Article 370, 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370, Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. The Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant.
Meanwhile, the Prime Minister, he has taken to the microblogging website X and put his particular opinion on the latest judgment that has come out of the Supreme Court. He says today's Supreme Court verdict on the abrogation of Article 370 is historic and constitutionally upholds the decision that is taken by the Parliament of India on the 5th of August 2019. It is a resounding declaration of hope, progress and unity for our sisters and brothers in Jammu, Kashmir and Ladakh. The court, in its profound wisdom, is what the Prime Minister says, has fortified the very essence of unity that we as Indians hold dear and cherish above all else. I want to assure the resilient people of Jammu, Kashmir and Ladakh that our commitment to fulfilling your dreams remains unwavering. We are determined to ensure that the fruits of progress not only reach you but also extend their benefits to the most vulnerable and marginalized sections of our society who suffered due to Article 370. The verdict today is not just a legal judgment, it is a beacon of hope, a promise of a brighter future and a testament to our collective resolve to build a stronger, more united India. This is being put out by the Prime Minister Narendra Modi. Meanwhile, the Home Minister, he was also quite quick to take to the microlong website. He says, I welcome the Honorable Supreme Court of India's verdict upholding the decision to abolish Article 370. He also goes on to say that on the 5th of August 2019, it was in fact Prime Minister Narendra Modi ji who took a visionary decision to abrogate Article 370. Since then, peace and normalcy have returned to J&K. Growth and development have brought new meaning to human life. In the valley once torn by violence, prosperity in tourism and agricultural sectors has raised the income levels of the residents of both Jammu and Kashmir and Ladakh. Today, the Supreme Court's verdict has proved that the decision to abrogate Article 370 was completely constitutional. And he also goes on to say that after the abrogation of Article 370, the rights of the poor and deprived have been restored, and separatism and stone pelting are now things of the past. The entire region now echoes with melodious music and cultural tourism. The bonds of unity have strengthened and integrity with Bharat stands reinforced. Now, ladies and gentlemen, this is also something that the government was constantly putting across during the trial, the 16-day long hearing as well. And we have some of those visuals as well. Why don't we throw them up on the screen for everybody to consume? People are distributing sweets. There are flags, tricolors that are filling up the sky. There is proper dhol, nagada. It's a proper celebratory vibe that you can pick up from Jammu and Kashmir at the moment. And that's not all. If G20 was something to live by, the G20 tourism meet was specifically held in Srinagar. The beauty and how tourism, the economy has been boosted since the abrogation of Article 370 was one of those prime points that the government constantly put across in front of this 5-judge bench, ladies and gentlemen. There were security frisking, some security protocols and arrangements that were made right in the morning, not so as much, but this is what Kashmir essentially looks like today. You've got the big cinemas that have reopened up, Jawan, Pathan, Oppenheimer, all Hollywood and Bollywood flicks making their way into the valley, and the beauty of the valley that, well, is of course world renowned. No news over there particularly in terms of the tourism sector, the jobs that has catered to, the economy that has been boosted because of it. That is another major point that the government constantly put across in terms of its argument in front of the Supreme Court, that abrogation was but all necessary, the abrogation was needed, and the abrogation has, well, led to more jobs. It has boosted the economy. It has brought down the stone pelting and infiltration. Those numbers and facts that the Solicitor General also put in front of the Chief Justice of India. And that's not all. The cherry on the top being that full statehood is going to be restored very soon. The Solicitor General was on record saying that the panchayat's been done with, the municipal elections, these were our focus initially. Now full restoration of statehood is going to be restored as well. Meanwhile, ladies and gentlemen, Asaduddin Owaisi, AIMIM chief, who's been one of those prime voices against the abrogation of Article 370, he's written a full-blown piece on the microblogging website, in particular points why he thinks it was not the right thing to do. Meanwhile, we've got a voiced bite reaction coming from Asaduddin Owaisi as well. Let's quickly listen into that.
सुप्रीम कोर्ट सुप्रीम जरूर है, मगर आप स्टेट होल्ड को एट द अर्लीस्ट रेस्टोर, अर्लीस्ट का मतलब क्या है? यानी आप यूटी कर दो और फिर आप बोल दो हाँ अर्लीस्ट कर दो। अर्लीस्ट कब होगा भाई? आप कब हुआ था? 2019, आज कितने साल हो गए? अब तक आपने रेस्टोर नहीं किया। अब चुनाव होंगे, चुनाव के बाद देखा जाएगा। सबसे बड़ा नुकसान तो जम्मू के डोगरा के लोगों को और लद्दाख के बुद्धिस्ट को होने वाले आगे जाकर।
Well, let's also listen in to Karan Singh next, another major stakeholder and a voice that is of grave significance vis-a-vis the abrogation of Article 370.
मेरी पहली प्रतिक्रिया तो ये है कि सुप्रीम कोर्ट ने बहुत बारीकी से हर एक विषय को देखा है। जो मैंने सुना चीफ जस्टिस जो पढ़ रहे थे, उसमें एक एक क्लॉज, एक एक सब क्लॉज को उन्होंने देखा है और सब परिस्थितियां देखते हुए उन्होंने एक नतीजे पे पहुंचे हैं। मैं उसका स्वागत करता हूं, क्योंकि बहुत दिनों से ये बात हवा में थी। तो अब कम से कम स्पष्ट हो गया है कि जो हुआ वो वैध था। राजनीतिक रूप से चाहे कोई समझे कि नहीं होना चाहिए था, वो बात और है, लेकिन लीगल दृष्टिकोण से, न्यायिक दृष्टिकोण से वो वैध है। एक तो बात ही हो गई। दूसरी दो बातें बड़ी अच्छी सुप्रीम कोर्ट ने कही। मैं तो चंद्रचूड़ जी को, सुप्रीम कोर्ट को बधाई देता हूँ। एक तो उन्होंने कहा कि जल्द से जल्द हमारी स्टेटहुड फिर से मिलनी चाहिए। मैं आरंभ से कह रहा था कि जो जम्मू कश्मीर को काट के दो हिस्से में करके और इसको यूनियन टेरिटरी बना दिया, वो हमें स्वीकार नहीं था किसी को भी, किसी के गले से नहीं उतर रही थी। क्योंकि जम्मू कश्मीर एक बहुत विशेष राज्य था। पहले कहते थे ये मुकुट है, ये भारतवर्ष का ये है, और मुकुट क्या रहा, फिर हरियाणा और हिमाचल से भी नीचे आ गए, यूनियन टेरिटरी बन गए। तो वो जल्द से जल्द, मैं समझता हूँ, मेरी मोदी जी से भी यही प्रार्थना होगी कि अब वो जल्द से जल्द राज्य का दर्जा दे दें। ये जरूरी नहीं कि पहले चुनाव हों फिर उसके बाद राज्य का दर्जा दिया जाए, बल्कि अगर चुनाव हों तो राज्य के लिए हों, यूनियन टेरिटरी के लिए क्यों हों।
Well, meanwhile, let's also listen into some members of parliament as well, some political leaders. Let's listen into what Arvind Sawant had to say. We've got reactions coming across from local people, some common people from Kashmir, from common people who we caught hold of right outside the Supreme Court premises as well. What is their opinion on it? Take a look.
स्वागत है ना, उसमें क्या। आपको पता होगा, वंदनीय हिंदू हृदय सम्राट बाला साहब ठाकरे जी देश में पहले शख्स है, राजनीतिक नेता जी। उन्होंने कहा था कि कश्मीर को मुख्य धारा में लाने की आवश्यकता है। ये 370 धारा खत्म करने की बात उन्होंने की, मांग करते रहे। आखिर वो मांग 2019 अगस्त में हुई। इस मांग के लिए कोई डिफरेंस नहीं है, लेकिन जिसके लिए हमने 370 धारा खत्म की, वो जो कारण थे वो आज तक नहीं साबित हुए सही, क्योंकि हमने चाहता हिंदुओं का पुनर्वास, हमने चाहता आतंकवाद खत्म हो जाए, हमने चाहता कश्मीर की जनता मुख्य धारा में आनी चाहिए, आज भी नहीं हुआ। यही तो खंत है ना, वो सोच छोड़ो, कानून सही था गलत था, चलो ठीक अच्छी बात है, कानून सही था, संसद ने पास किया था। वो एक मसला था कि भाई विधानसभा नहीं है, एक तकनीकी मुद्दा लेकर बात करते थे, लेकिन मांग तो ये थी कि 370 धारा खत्म करनी, तो कब हो गई। लेकिन हम हिंदुओं का पुनर्वास, एक घर भी नहीं बसा पाए हम 5 बरस में, और एक भी हत्या हमने रोक नहीं पाए। आज भी कश्मीर के जो हिंदू बचे हुए हैं, जो सरकारी नौकरियों में हैं, वो बार बार हाथ जोड़ रहे कि हमें वहां से निकलकर सीधे जम्मू या कहीं और ट्रांसफर कर दो। तो उसके लिए आपके कैप में फेदर है क्या? कोई आ गया, कोई कैप्शन मिल गया, क्या कहूँ, बख्शिश पाया क्या आपने? नहीं पाया ना। वो हमारा दर्द है। दर्द 370 धारा खत्म नहीं, तो आपने मांग की थी, सही बात है, लेकिन जिस कारण जिसके लिए की थी वो आज तक सही साबित नहीं हुई।
Well, so voices of affirmation, voices of happiness, but on the other hand, voices of dissent and voices a little bit of concern as well. What's going to happen in the days to come? How soon can we expect assembly elections to be held over there? The Election Commission has been given clear directives by the CJI. But meanwhile, the big news still remains. It's an important day, a historic decision that's coming across from the Supreme Court. It has upheld the constitutional validity of the abrogation of Article 370 at the hands of the Union government back in 2019 on the 5th of August that year. 4 years on, the Supreme Court has said, well, it was completely legal. And not just that, the bifurcation, the Reorganization Act of Jammu and Kashmir, that has also been legally upheld. The bifurcation, it seems, was done and carried out in the right way. Now, all of this is done. But what next? The ifs and buts, they will now start trickling in. And of course, you can vouch on News 9 Live to bring you all the latest details and development. Meanwhile, just a quick recap that's coming on your screens as we speak, ladies and gentlemen. The CGI has said, and these are the topmost points, the President has the power to abrogate Article 370. That's point number 1. It is also said that Jammu and Kashmir did not retain the element of sovereignty after it joined the Union of India, another major and operative part. It also said that Article 370 was in fact a temporary provision, something that it had to adjudicate on. Now, all provisions of the Constitution can be applied in Jammu and Kashmir. Another important aspect, right to education, RTI, women being married outside of the state but not getting citizenship, who's going to buy land, who all can buy land, all of those questions can be covered in this. The Supreme Court cannot sit in appeal on the presidential order, the 273, the CO 273 that was in question, another operative part. And in terms of finalizing this recap, the Supreme Court has struck down on the Constitutional Order 272 as ultra vires. That is what we're picking up, ladies and gentlemen, at the moment. The Supreme Court has also directed the Election Commission to hold Jammu and Kashmir Assembly elections by September 2024. Let's not jump the gun, let's not put a date over there, but it's crucial and it's important that Assembly elections is being spoken about at the Supreme Court as well. Statehood of Jammu and Kashmir shall be restored as soon as possible. Well, a win for the Modi dispensation or a loss for the opposition at the moment? Well, again, we'll have to wait and find out for a little better understanding of what's really happened. But the big news is abrogation of Article 370 constitutionally upheld, ladies and gentlemen. We're closing down this particular segment, but listen in to all these major reactions and operative portions from the CGI to the local people that are actually affected by Article 3.
मेरी पहली प्रतिक्रिया तो ये है कि सुप्रीम कोर्ट ने बहुत बारीकी से हर एक विषय को देखा है। जो मैंने सुना चीफ जस्टिस जो पढ़ रहे थे, उसमें एक एक क्लॉज, एक एक सब क्लॉज को उन्होंने देखा है और सब परिस्थितियां देखते हुए उन्होंने एक नतीजे पर पहुंचे हैं। मैं उसका स्वागत करता हूं, क्योंकि बहुत दिनों से ये बात हवा में थी, तो अब कम से कम स्पष्ट हो गया है कि जो हुआ वो वैध था। राजनीतिक रूप से चाहे कोई समझे कि नहीं होना चाहिए था, वो बात और है, लेकिन लीगल दृष्टिकोण से, न्यायिक दृष्टिकोण से वो वैध है। एक तो बात ही हो गई। दूसरी दो बातें बड़ी अच्छी सुप्रीम कोर्ट ने कही। मैं तो चंद्रचूड़ जी को, सुप्रीम कोर्ट को बधाई देता हूँ। एक तो उन्होंने कहा कि जल्द से जल्द हमारी स्टेटहुड फिर से मिलनी चाहिए। मैं आरंभ से कह रहा था कि जो जम्मू कश्मीर को काट के दो हिस्से में करके और इसको यूनियन टेरिटरी बना दिया, वो हमें स्वीकार नहीं था, किसी को भी, किसी के गले से नहीं उतर रही थी। क्योंकि जम्मू कश्मीर एक बहुत विशेष राज्य था। पहले कहते थे ये मुकुट है, ये भारतवर्ष का ये है, और मुकुट क्या रहा, फिर हरियाणा और हिमाचल से भी नीचे आ गए, यूनियन टेरिटरी बन गए। तो वो जल्द से जल्द, मैं समझता हूँ, मेरी मोदी जी से भी यही प्रार्थना होगी कि अब वो जल्द से जल्द राज्य का दर्जा दे दें। ये जरूरी नहीं कि पहले चुनाव हों फिर उसके बाद राज्य का दर्जा दिया जाए, बल्कि अगर चुनाव हों तो राज्य के लिए हों, यूनियन टेरिटरी के लिए क्यों हों।
यूनानिमस जजमेंट थी, ये सर बहुत निराशा हुई, बहुत अफसोस हुआ। मैं शुरू से ही कह रहा था कि दो अदारे हैं जो इसका फैसला कर सकता है, एक पार्लियामेंट, मरकज़ी सरकार, और दूसरा सुप्रीम कोर्ट। जाहिर है मरकज़ी सरकार करती नहीं, उन्होंने तो आर्टिकल 370 को ख़त्म किया, कानून बनाकर नया। अब ये आखिरी हमारी उम्मीद थी कि सुप्रीम कोर्ट इसमें सुनाई करे और इसका फैसला सुनाए। 3 महीने 4 महीने इस पर बहस हुई पार्लियामेंट के अंदर, और मुख्तलिफ वकला ने अलग अलग पार्टीज़ को और रियासत जम्मू कश्मीर के लोगों को रिप्रेजेंट किया। और उसके बाद जो आज यूनानिमस फैसला आया, उससे मेरे ख्याल में जम्मू कश्मीर के सभी लोग, चाहे वो कश्मीर के हों या जम्मू सूबा के, वो खुश नहीं है। मैं आज भी समझता हूँ कि ये हमारी रीजन के लिए एक हिस्टोरिकल चीज़ थी। हमारे जज्बात जम्मू कश्मीर के लोगों से इससे जुड़े थे, चाहे वो 370 हो या 35A हो, जिस 35A को महाराजा हरि सिंह ने 1925, 1927 और 1928 में बनाया था कि बाहर वाला न नौकरी कर सकता, न बाहर वाला ज़मीन खरीद सकता। और जब हमारा आईन बना तो 35A की शक्ल में उस महाराजे को फैसले को आगे बढ़ाया था। तो आज वो भी ख़त्म हो गया, दोनों चीज़ें ख़त्म। इससे हमारी स्टेट की इकानमी को बहुत नुकसान होगा, ज़मीनें महंगी हो जाएंगी, पूरे हिंदुस्तान के लोग जम्मू और श्रीनगर आएंगे। हमारी महदूद, हमारे यहाँ कोई बड़ी इंडस्ट्रियाँ नहीं है कि जिसमें हज़ारों या लाखों लोग काम करें। हमारी सबसे बड़ी इंडस्ट्री है टूरिज़्म, और वो लिमिटेड लोगों के लिए है। हमारी सबसे बड़ी इंडस्ट्री जम्मू कश्मीर की है नौकरी, सरकारी नौकरी, और उसमें भी अब और बहुत कम नौकरियां होती। ज़ाहिर स्टेट बहुत छोटी है, अब उसमें पूरे मुल्क के 130 करोड़ जो आबादी हमारे में वो अप्लाई कर सकते हैं हर महकमे के लिए। तो हमारे जो नौजवान बच्चे हैं या बच्चियां हैं पढ़ी लिखी, वो और बेकारी हमारी बढ़ेगी, कई गुना और ज़्यादा बढ़े। तो ये तमाम चीज़ें जब रखी गई थी आर्टिकल 370 में, 35A में, 35A में, इन तमाम चीज़ों को नज़र में रखा गया था कि एक बॉर्डर स्टेट है, एक तरफ से चाइना है, दूसरी तरफ से पाकिस्तान है, और कोई यहाँ ज़रिया आमदनी नहीं है, कोई खदानें नहीं है, बड़े कोयले की खदानें या दूसरी खदानें। तो ये चीज़ें आर्टिकल 370, 35A रखना चाहिए। मैं ये तो नहीं कह सकता कोर्ट से भरोसा उठ गया, लेकिन ये था कि एक उम्मीद थी, क्योंकि कई चीज़ों में हम सब ने, हिंदुस्तान के हिंदू मुसलमान ने पिछले कई सालों से कहा था जो कोर्ट करेगा वो आखिरी फ़ैसला होगा। जैसे बाबरी मस्जिद के बारे में कहा था, इसी तरह से और कई चीज़ों में कहा था, और उसको स्वीकार किया था। तो अब हमारी उम्मीद थी कि सुप्रीम कोर्ट, क्योंकि वो किसी दल की, किसी पक्ष की, किसी सियासी पार्टी से ताल्लुक़ नहीं रखते हैं, और ख़ास तौर से आज की जो ये बेंच था वो बिल्कुल मैं कह सकता हूँ कि बहुत ही अच्छा बेंच था।
वर्ष 2070 तक भारत नेट जीरो